Welcome to another edition of Law Talks. I'm Clay Williams, and I'm a partner here at FH&P Lawyers. And with me today is Ms. Wendy Cheung. Welcome, Wendy.
Thank you. Thanks for having me.
And so, Wendy, you are an associate here. You've been here for a while now. How long have you been here for?
February 2019.
Oh, well, okay. So it's been a bit. I know we've worked together quite a bit.
Yes.
And done some pretty cool stuff together.
We have.
And today you are going to tell us about your role as a mediator and an arbitrator.
Yes.
Okay. Well, what the heck is a mediator and what is an arbitrator?
Well, I'm also a lawyer. So in addition to being a litigator here, mediation and arbitration is really just moving into a role of what we call in the industry a neutral. And mediator is a person who facilitates disputes by hopefully getting the parties to come together and crafting their own resolution without having to go to court. And an arbitrator is someone who almost acts like a judge. Presumably, by the time we go to arbitration, if the parties are unable to settle, let's say, at a mediation, they would go to an arbitration and have someone who is a decision maker render a binding decision.
Okay, so like I've heard it said that a mediation is a consensual resolution, I guess.
That's right.
So and when you're acting as a mediator, you don't have the power to actually tell the people how to deal with their dispute. You have to get them to come together.
That's right. And the goal is to try to have them communicate and elicit what we call the best interests of the clients. And sometimes the best interest isn't even about what they're actually fighting about. It could be some kind of underlying need that both parties feel, sometimes just even to be heard, and try to get them to come together and craft a solution that maybe even a judge wouldn't be able to craft.
Mm. Well, actually, that's interesting you say that. Sometimes people just want to be heard. That's actually, exactly. I found that as well, that sometimes you'll find that people are fighting for reasons that aren't really properly articulated, I guess.
Exactly.
In a lawsuit, I guess.
Exactly, or can't be articulated. Mm-hmm. I mean, sometimes if there's, let's say, a shareholder dispute and the parties are actually family members, well, there's usually some kind of underlying history relating to the family relations that may not be relevant if we do bring it up in a court proceeding.
Okay, and when you act as an arbitrator, you are saying this is the resolution and live with it.
Yes, I mean, the parties pitch to you the case as if they would in a courtroom. Mm-hmm. Except they've chosen a more streamlined approach, a more informal approach, and you can potentially get to resolution faster. The other thing about arbitration, too, is that the process and the decision is confidential. Whereas if you go to court, if there is a decision rendered, it is made public.
Well, actually, that was my next question,
right.
Is why the heck would you, how do you get to an arbitration? We have this thing called court, and
yes.
Court is a very effective way of resolving a dispute.
Yes.
So I'm hearing confidential, but is there any other reason that you would want to do an arbitration? Yes.
I mean, again, it's more of a streamlined approach. It's a bit of I've heard someone say it's like a choose your own adventure novel. Mm-hmm. And so when you go to court, there's a specific set of rules that you have to abide by in getting from day one, filing the claim, to day, let's say 300, when you finally appear before a judge. There's many steps in between that you have to do that could add to the cost, the legal fees. Whereas in arbitration, you can choose to skip some of those steps, obviously with the agreement of the other party and the arbitrator. And so there could be some cost savings there. The other thing, too, is that the arbitrator actually works with you from start to end of the entire dispute. Whereas if you go to court, you won't know who your judge is until the day you step foot in the courtroom.
With respect to an arbitration, it's my experience that, my clients kind of end up in an arbitration because it involves an agreement where they previously already agreed to be in an arbitration.
Exactly.
I'm not as big a fan of arbitration as I guess you are, being an arbitrator.
Yes.
Because, one of the downsides is that you do have to pay for the arbitrator.
Yes.
So while there may be some cost savings in these steps, you're effectively paying for your judge.
That is true. So that is the one con, if you will, of arbitration, is that Typically, you don't have to pay a judge, but you do pay an arbitrator hourly. And right now, the going rates are pretty high. And I think there is a component when, let's say, the parties have agreed to arbitration in a contract, and then when they do dispute, they are bound to this process, if either one of them so choose. I think there is almost like a psychological component that if they have to pay for an arbitrator from day one, maybe there's more of a desire to have it resolved earlier on to cap those fees.
Well, that's the other thing I was going to say is, one thing about our court system is it's pretty overloaded.
Yes.
And counsel are overloaded, and just getting a trial date, getting this thing resolved can take years. And that doesn't necessarily have to be the case with an arbitration.
Absolutely. You can get a dispute resolved in arbitration, depending on the scope and the complexity of the case, for as short as 6 months. Within 6 to maybe 18 months. Whereas I think if you, let's say, run a similar type of dispute in court, you can be looking at anywhere between 2 to maybe even 6, 7 years.
Yeah, it can take a long time depending on the dispute. So some of the arbitrations that I've been involved with were, landlord and tenant in the commercial sphere. And so, for our listeners, usually in a commercial lease, and when there's a renewal, you can exercise your renewal. And if you can't agree on a new rent, then it goes to arbitration. There's an example. Oftentimes in acquisitions, there's working capital adjustments and those type of things. So, but then there's also all-encompassing things like with the share purchase. All matters involved in the share purchase and dispute have to go to an arbitration.
Any sort of dispute.
And that's where I'm iffy sometimes, because when you get a lot of different issues, I wonder if arbitration is the way to go. But yeah, I'm just being telling what I think. I know you'd have a different
absolutely
take on that.
And I mean, the thing too with arbitrations is sometimes, even though the decision is binding and the process can still be lengthy to get there, there's still a review process for arbitrators. So parties who don't necessarily like the decision of a binding arbitration can still go through a process. Typically, it's called a judicial review, and then that gets heard by a judge to decide whether or not the arbitrator made some sort of error.
Okay. And so, I guess I should ask you this right off the bat. How do you get to be a mediator and an arbitrator?
Interestingly,
look, it's in my notes.
Yeah, I know.
I should have put it up here. So.
Interestingly enough, the mediation and arbitration industry, let's call it, in British Columbia at least, is not a regulated profession. Anyone can actually go out and hang their hat and call themselves a mediator or an arbitrator. That being said, you would probably market yourself a little bit better if you do have some experience in disputes. So whether as a legal counsel or in employment situations, union reps, those kinds of positions. The path that I went through was I took my education. I did my academics. So for mediation, there are courses you can take. I took mine through the Continuing Legal Education of BC. And I also went to Boston one summer and went to Harvard Law School and did a 40-hour training there. And I also recently just did my arbitration training through Royal Roads University in Victoria.
Okay, Harvard. That's pretty. Pretty impressive. That's and was that for? Is it the same process to become a mediator as it is to become an arbitrator, or are they different paths?
Again, you can choose to not take any courses at all. You can just choose to call yourself a mediator arbitrator. The nature of the courses are different. The mediation courses, a lot of it is based on good. They're teaching you good listening skills, effective communication skills, and language like feedback loop. So as mediators, we want to always feedback what the other person says to us to make sure we understand and to make sure the person who's telling the neutral, the mediator, what they feel are their interests, they want to feel like they're heard. Whereas arbitration, a lot of the academics basically is about how to render a fair and sound decision.
Okay, because you're right, there is a review process.
Yes,
so you have to make sure you get your law right, make sure you're dealing with the evidence properly.
Exactly. So
maybe I'm wrong, but I would think that our listeners are probably going to be more familiar with, or will end up in a mediation probably more than in an arbitration.
Very likely.
And so I guess, can you tell us like what might our listeners expect if they were involved in a mediation?
Yes, absolutely.
What's the process, I guess?
Absolutely. First of all, mediation is primarily you have to enter into it. Both parties have to enter into it voluntarily. Now, there is a regulation in British Columbia where you can force the other side to go to mediation.
Oh, there's a bunch of regulations.
Yeah,
one in the construction, one in the personal injury's kind of got over the waste, but some of the different fields, and then there's a general one as well.
Exactly. So you could force someone to go to mediation, but for the most part, ideally, you would like the parties to go into the mediation because they want to, and that's step one. That's always step one, right? Is getting that foot in the door. Because now the mediator knows, okay, you are here because you may want to avoid the uncertainty of trial and that you are both here because you hopefully want a resolution sooner rather than later.
You know, I'm not sure I agree with that statement. I mean, there's a lot of times where we're, in a litigation file where we will force a mediation. What's the problem? Why aren't we settling? What evidence do you have? Am I missing something in the case? So, even if there isn't a settlement, sometimes it's very, very useful to have that mediation. Get a feel for what is going on. Is it the client that has dug themselves in, or is the lawyer? Where is the point that we can that we need to know about here? So
absolutely, and oftentimes, if I'm putting my lawyer hat on, I tell the clients that mediation is a process where it's almost like a bit of an investigation process for us to find out what the other side could rely on and may want to say if it doesn't settle, if it goes to trial. Now, obviously, the caveat there is everything that is exchanged in the course of mediation is what we call without prejudice. So you can't use anything that is said, offered, conditionally accepted in a mediation and use it at trial as evidence. But certainly, mediation, the process is good for more than just settlement.
Oh, I think of a case that we did recently, and I think of the mediation, and what we learned from that is these people aren't going to settle.
Well, exactly.
There's no point in spending any more time on this.
Writing
Let's just get this thing going to trial.
Exactly.
And so really a useful process.
It is. It's a very useful tool, and sometimes you just need, if let's say I'm acting for a client and the opposing counsel is acting for their client for a very long time, sometimes you almost need a different perspective to come in. And if you don't want that different perspective to be a judge who's going to render a decision, you just might want to rely on the neutral, the mediator, to maybe knock some sense into one or both of the parties.
Yeah, that's a good point. I've done that many times oftentimes your mediator is a very experienced trial lawyer, for instance.
Yes.
And so if that person comes in and has the respect of both lawyers, I've had that speech, have you considered this or this or this? And that can certainly help as well.
Yeah, and that's the two kind of primary styles of mediation, that's facilitative or evaluative. You can ask your mediator, if you were a judge, what would you lean towards? And they can give their opinion if you so ask. And that could very well influence the course of the resolution or the negotiations, or it could very well, and the thing about mediation is, if it doesn't settle in that day that you have set aside for the mediation, the momentum that was created in that one day could carry over until, let's say, the day before trial. And parties can realize, well, there's been something happening there since the mediation that has kind of led us to deciding to resolve just shy of trial.
Do you have any comments about when parties should engage in mediation? Early, later? I mean, obviously you're going to take the advice of your counsel, but do you have any personal thoughts about when that should happen?
I do. A lot of it depends on the nature of the dispute. I find for me a lot of contractual disputes, I actually like to encourage mediation, and I've done this on some occasions, and it's actually worked. I like to encourage mediation before the parties file their pleadings.
Oh, wow.
Yes.
That's a tough one.
And it's happened, and it's been successful. And I think for both parties, it was the threat of filing of pleadings and then going down that path, even though you can mediate the day after you file pleadings. But it was almost a threat of having that public document. In this case, both members, one was a more prominent member. It was a member who was in office, who likely didn't prefer to have documents filed that could be public, and so we had encouraged both parties to mediate prior to filing pleadings. Now we had actually exchanged pleadings, but unfiled, so that the mediator had at least something to work off.
Okay.
And it settled.
Well, that's a good story.
Yeah.
I guess personally, my experience has been, the lawsuit, document discovery, usually at least
after.
some oral discovery.
Yes, absolutely.
And then you kind of know the case.
Exactly.
So you know what that person's going to say, you know what the defenses are, and
exactly.
And then it's just really, assessing risk and how much.
Yeah, I would say 85% of the time we engage mediation in with some seriousness after examinations for discovery.
Okay.
Yeah.
Do you have anything else to say about mediation or arbitration that I haven't asked you about?
It's a great tool. ADR is a great tool for today. Again, we have a shortage
and
of
ADR,
judges.
just for our listeners, stands for
Alternative Dispute Resolution, and it includes mediation, includes arbitration, and it even includes negotiations. So the pre-mediation, pre-arbitration stage where counsel is just exchanging without prejudice letters, right? They are all useful tools in light of the fact that right now we are dealing with a shortage of judges. We're dealing with long waiting times for court times, and one of the things right now is that we are all just such busy professionals and individuals. Even with individuals dealing with disputes, we just want some certainty. And if time is precious to you, then I would strongly encourage that your counsel talk you through ADR options, mediation or arbitration, to help facilitate a faster resolution, whether it's binding or whether it's one you craft with the other party yourself.
Fantastic. I hope you learned something about mediation and arbitration. Till next time.